Madam Chair, I'd like to make a motion that we approve the minutes of the March 16th Policy Committee meeting.
Second.
All in favor? That's unanimous. Next, the agenda.
I'd like to make a motion that we approve the agenda for today's meeting, March 23, 2022.
Second.
All in favor? Okay. We're gonna try to keep this short and sweet. We're gonna move quickly, so don't think I'm rude if I move us on.
We won't.
All right, so we're gonna start with the discussion of policy KEC, public concerns and complaints about instructional resources, and the also the administrative rule. So that's in Exhibit A. So, actually, maybe we should start with Ms. Hannah. Would you like to address this?
I will, thank you. Is mic on? You can hear me? I appreciate your bringing this to us because we know that we had so much public participation about it, and we know that all 7 of us on this school board, along with the administration, want to know that we have, parents have a voice in what's in our schools, but we also know that we, as a public entity, that, we have to have a process about books. It has to be a process. What I wanted to bring up is I was concerned that we had negative press about not doing our job, which was not true at all. And I have talked with the governmental affairs person at the state superintendent's office, and I've also talked with the governor's office, and we do have to follow a process. But what I do think we need to do is look at our process. I think that from what I'm hearing from parents, it's a lot of hoops to go through. There are a lot of you got to fill out several forms. I think if we could simplify the number of forms. I also think that if we could zero in on obscenity, Ms. Gardner, not different opinions, not different thoughts in books. That is certainly not what this board's about. But I did find out, and I did discuss this with the governmental affairs person at the State Department. There is a law, and I wrote it down. I hope I'm right. Code of Laws, Title 16, Chapter 15, Offenses Against Morality and Decency, which is actually a state law, not a school law, but it's a state law. So I was hoping with this group we could discuss whether or not, as we shortened our process to have a book reviewed, we also could mention this law, so that would cover us as far as obscenity, because there is a difference in obscenity in a book and a different perspective or point of view in a book. So that was why, and I so appreciate you bringing this to us, because it might not be one meeting that will solve all this, but I did want to talk about it. And then my only other point is, how could our administration, I think what question I got from a lot of parents was, how is there any process that begins at our media center point that we could know there are no obscenity books getting put there? Like in other words, prevention, rather than now having to look through books in this process of figuring out, do we have any books with obscenity in it? So could we look at that, Dr. Ross, how that happens? So that was it, and that's all I want to say. But I look to Ms. Huddle and Ms. Gardner and Mr. Lovelace. I appreciate y'all being here that we can tackle this. Thank you.
So is there any thought on, so the model policy that they've given us is quite extensive compared to ours, but to me it doesn't, I don't know. What do you think? Does anybody see any differences?
Where did this one come from, Ms. Gardner, that we've got in front of us? This is ours, or this?
So ours is page 1.
Okay.
And if you go to page 6, that is the model policy.
From
I don't know if that's the administrative rule model or if that's the model policy they want to change our policy to.
Is that from the School Boards Association?
No, actually, isn't this from?
From the
From the
State Department. Okay, that's good.
I have a question. Okay, in remembering the debate that we had in the school board meetings, it seems to me that there's a difference in the interpretation of the definition of obscenity, because the Supreme Court in the Miller case had a three-prong, am I right? A three-prong determination for what obscene means. Supreme Court of the United States, that is. And then in the state law, I'm not sure that the state law that you just gave us the
And I don't have
code
a
number
copy
for.
of it, yeah.
I'm not certain that state law addresses, it was a definition of obscenity in general for criminal activity, right? Which is different from the U.S. Supreme Court's three-prong approach to determining obscenity in relationship to a book, right?
So, yeah, I can speak to what our legal advice was regarding the definition. We were asked, what's the definition, or what definition is District 5 use for obscenity? And our attorney at the White looked like that there is a three-prong test. In fact, she spoke about that in public session. This three-prong test is what we use the review committee to determine the difference between pornography, the pictorial representations of sex acts and things of that nature. That, of course, not allowed unfiltered, not allowed in schools. I do have with me Phil Lumsford, who is our coordinator of instructional technology and qualified as an expert to help us with that process. She also works with our school librarians in determining how we vet information into ours, and then how we go through the review process. What you see, as Trustee Burton said, is we have our current policy that has a rule that has that form. And then you have the model policy that came from Ms. Lunsford,
Came from the State Department on January 25th.
so it was the day after that, that meeting, the State Department put out a model policy. What you will see in their model policy, correct me if I'm wrong, it takes our administrative rule and our policy and combines it.
Additionally, it pulls in our policy IJL, and ties all three of those together into one model policy.
That's what I thought. Are we gonna divide those out back to where they should go, or are we going to look at all the policies like they suggest?
I would think, and correct me if I'm wrong, Ms. Lunsford, if we combine, if we accept this as is, as our new KEC, it would now bring in room for review, or to be dismissed, and then what about IJL, would that also?
We would also have to look at IJL. But it would bring them all under the umbrella of material and reviewing instructional materials.
Because I think it says public concerns and complaints is KUC, but this model policy is for the library's, the material selection, and so it's not quite the same thing.
The model policy actually goes into the material selection and consideration if someone has an issue.
Is that the IJL,
IJL is the Library Media Center material selection and adoption. So that is the selecting of, and then, but the model policy covers both KEC and IJL.
So that might be nice.
Yeah, if you divide it out, the model policy, the top part that ends before material selection basically is KEC. The middle section is basically IJL, and from procedures on down is basically KECR. So, you know, we're not voting here, but one proposal we could make to the full board is to either break this out in 3 sections to replace the current policy, or whittle down our 3 sections into one.
Yeah,
I get it.
I like that.
I guess to go back to my original question though, Ms. Lunsford, okay, what my concern is, I'm just gonna spit it out here. I'm concerned that if we pass something that was a policy that had a different definition other than what the Supreme Court had, that we could possibly set ourselves up for a ACL type lawsuit, ACLU, whatever we call it, type lawsuit, because we weren't, you know, this has been decided in the 60s, I think, this issue, and that I want to make sure that we're not passing a policy that has a definition other than what the Supreme Court of the United States ruled on, and therefore it would set us up for a possible, you know, assault by a lawsuit that we'd have to defend ourselves on. And I think if we handled that properly right now, we would necessarily remove that possibility. That's what I'm asking.
Can you restate your question for me?
Well, the
Specifically?
question is that, you know, if we're using a definition under a state criminal statute that's different from what the United States Supreme Court has already ruled on, okay, and that is mentioned in any of these policies anywhere, then I'm concerned with the fact that we would be setting ourselves up for a possible.
I do not see in either the model policy or our policy a definition of obscenity.
Okay, so it doesn't address that whatsoever, what it is. So we would be going by what the Supreme Court of the United States has already ruled by, and that's, you know, ruled on, and that's important.
And for us, because we have First Amendment rights in limbo here, I am very comfortable with either keep our policy or adopt the model policy. Or else we need legal advice, and we don't want to, under this Miller case, which is established law, we don't want the administration getting into confinements.
That's what I was trying to get at. So we either go by what we have, or then we approve completely what the State Department has asked us to do, and we don't make any variations.
I'm very comfortable with what we either adopt what we have, or we adopt what was put out by the State Department on January 25th.
Okay, well, that was basically where I was going with that. Okay.
So it doesn't address obscenity, so they can still get into our schools.
Yeah, I've got a
Materials,
problem
we
with
don't
that.
have a way to stop that in our policy at all.
Maybe we should ask the state.
That's what I
You
said.
know, they're the ones that said we weren't doing our job.
Yeah.
So why don't we ask them?
That's a good idea. We need to ask them why is their model policy not have the word obscene in it when they're the ones that even brought that up, so I think that's my next step.
And Ms. Gardner, I certainly appreciate that cover. In fact, there's one thing, and I'll go back on what I just said. There's only one thing that I would ask that we look at within the model policy. And the vetting, we have in our current policy where we don't put anything in our libraries that has not been on the selection aid approved by the state. The state has a selection aid process, which allows us to say, we don't just pull any book that could be in the public library and put it in our libraries. We use the selection aids as provided by the state. In the model policy, it removes the state selection aids. We want to go more further. We want our librarians to use the state selected aid. Every book that was brought to our attention was on the state selection aid list. So when we talk about vetting, why now remove that when that was one of the filters that we had in place prior to this point? So that's the only, as far as the administration, is if we adopt a model policy, we should keep that we continue to use the selection aids as kept by the state, as approved by the state.
But that's already in our
That's in our current policy, KECR.
KECR, okay. Yeah, go ahead.
This is a question for Ms. Lunsford. Besides what Dr. Ross just spoke of, the selection that's set up by the state, do librarians at the local level still choose books that you can choose, or they have to be already set up and approved by the state before we can buy them for our libraries?
The books that they select are reviewed through the aids that are provided by the state.
But I get that, but I'm saying, could, not just Lex 5, could any school district choose books that haven't been approved by the state?
The state doesn't have like a master list of books that have been approved.
Okay.
They've given approval sources to use in reviewing books to pull into your collection.
Oh, okay. But, and so then the individual school districts, media centers, choose the books from their list?
They choose the books, they get a recommendation from, whether it's a teacher, a student, someone that has made a recommendation that they would like a book in the collection, and then they do their research to review that.
Well, I can't help but continue to ask the question, because I think we were all shocked, for lack of a better word, that night when we had books that were in a library here or somewhere in our district, and we had that read to us, and it was offensive to all of us. But you know, the point to a lot of parents was, if that's in a book in a library and my child can get it, this board certainly needs to know about it and be shocked herself, because we're shocked. I'm not saying that was right or wrong, but I think my question goes to, and these books that they were complaining about were there way before Dr. Ross was superintendent, way before. I think some went back to 2014 or 13. So I have a problem with this board or Dr. Ross's administration being blamed for something that we didn't really put there, and really are now, as a really good board that's trying to do our homework to find out how this happens, how we can protect our children from obscenity and still follow all the laws of books with all the, like you're saying, that we aren't hamstrung, and on the other side we have people that come at our district because they want certain books in our library. I get all that, especially as a teacher, but I really just, it seems like at least the State Department of Education, if they're vetting and giving you lists, I guess I'm trying to go forward. I don't think we can fix what was done before us, but we can go forward with a way that we can ensure pornography, not pornography, but obscenity is not in our district. So that's.
Ms. Gardner, I might recommend that before we adjust this policy, that maybe the administration send a letter to DOE and ask, because the policy that they gave us does not address obscenity. So before we change policy, perhaps we should ask the DOE, because you read this, those books that were offensive would still make it through under this policy. So I would just recommend we table this until we get some information back from them.
And I would like also for us to address IJL at the same time to read it to see if we feel like we want to
Right.
throw some things out, or just update each policy, because I prefer our administrative rule over the one they gave us. I like it better, because it's got some more specific things in it. But I do understand that we probably should adopt their, I mean, it's pretty similar to ours, but I see how there are differences. The one major thing that I've seen that, I don't know what I know what our policy says now, but if we took it out, would it help? When somebody fills out the form and sends it in, our policy states that the document or the book has to stay on the shelf. Is that by law, or is that just because it's our policy? Because the new policy doesn't say that, so would we be able to at least flag it to where no one's allowed to check it out, or it has to be, the librarian has to keep it up front so that they can't find it on the shelf, but it's still in the library if the parents allow them to check it out? Like,
That's a great point, Ms. Gardner, and so we were trying to find a medium to Ms. Hammond's point. If that has made it through the legitimate filter, but I disagree with it as a parent, what protections would I have? That specific information was a memoir, right? Someone's account, and therefore passes through the filter. So what we have talked with Andrea White, our legal counsel, was developing a tag that would go in the Folly system. And so it says that your child is, we're still working on that process. I think we're going to be like the second district in the nation to even have such a system. But we tag this as a challenge book. And so it would need parental permission to be checked out. Therefore, it's still on the shelf. And we had a letter from the South Carolina South Carolina Association of School Librarians. And in that letter, they did say, which they provided both parts of this. They talked about the constitutional authority that the school district has, but also the rights of a parent to have controls over what a child reads, but not to have the rights over control what a child does not read. So we found that maybe the compromise here was, once it has been challenged, that book is now tagged and followed. When the child goes to check it out, and we're still working on that process, that it would now require parental permission. And then if the parent says, yes, I have no problem with my child reading one of these challenged books, then that student receives it. So we don't violate the First Amendment rights without due process, but we don't expose any student to challenged material without parental consent.
And in that, so I would like, when we get this going, in our administrative rule, I'd like to have a sentence or a paragraph about that, because that would be good.
So we're working on that form now, make sure that the legalese of that is legit, as well as the process, because we don't want it to be where we have to call every parent from the library. We're thinking about a way that you can just kind of sign up to make that process doable. Is that what something like?
And what a parent can do now is let the school or the school librarian know if there's a book that they do not want their child to check out. They can make a note to the child's account in Destiny that the child's not allowed to check that book out. So that's a process that's in place now. Yeah, we should put that in policy so that people know that that's an option. Because there's so many things that maybe parents don't know are an option.
That's a good point.
So you said that they say that the name of the program is Destiny is the checkout system that we use to check books out to students.
Keeps it followed.
It owns Destiny.
So how would the parent do that?
They just need to call or send a note in to the school.
To the school itself, not the teacher, to the school? Okay,
They could send it to their teacher to get to the school library.
okay.
But under the review of this, we're going to streamline that and find out maybe we can make it digital but currently, until that process is up, you can notify that librarian of the school.
Ms. Gardner?
But, it's just important to know that this policy still recommends them to fill out a form. I don't know if the newer form is any easier, but,
I think one thing about the newer form is, I've had someone say the old form, I think, requires that you have read the entire book, and the new form just asks, so that may help. That may be a,
that might be easier,
yeah.
'cause you might not wanna read the whole thing if you feel like this is.
Mhm.
My question is, this sounds like a good plan that a parent can say, I don't want my child to, check out X book. I think, though, parents don't know what books to say. I mean, I have a problem with the parent. No parent's gonna have the time or go into a library and look through books that they think I wanna put on a list that I don't want my child to read. So I don't know that to me
And that's
makes
what-
a parent very happy, because they still could be in that library and they don't know to tell you that this book, not to let my child see.
I agree. I think that's what we have now, but under review with what we're working with Andrea's Attorney White, is to make it all challenge books. So once you select that, then every book that's challenged would be off the list there. Or else we would not have a system to know what a child could have access to and not have access to.
So that, I think that's key, sorry, to cut in.
No, go ahead.
But it's important to note that it's really almost impossible for everybody to know exactly, to know exactly what's in every single book. We do need people to, if they find things, to voice it, to let us know. That's important.
But understand too, this is during the process. So, and I believe in due process. So during the process, this is a layer of protection. once the process is over and the committees find it is obscene, it's pulled now. It is no longer available. So you have 2 layers of protection. During the process, we can tag it in the Destiny Follic system. But after the process, and those committees determine that the recommendation for that book to be taken off the shelf, then no student has access to that text.
It's probably a wrap-up question, but this is for Ms. Lunsford, but are there been any filings of reconsideration of library/media center materials forms filed with the school district?
So those would go directly to Superintendent Ross, but none have come to my office.
So none of that has been filed, and we've had all of this discussion.
No, sir, we have not had a filing.
Okay, so the shock and awe was not actually to remove the books, it was just to embarrass. Okay, thank you.
Okay, so just as a recap, we're gonna, next meeting, we'll do IJL, and then I'll bring us along with KEC and KCR. And if we might be so bold to ask you to one of us could write it, but do you want, we need a letter to the Department of Education asking them where we should put the obscenity clause in their policy.
And we're waiting for that response. We've already reached out.
Okay.
And,
So would it help for us to, as board members, to also ask that question to someone?
yes, we have reached out. We have yet to get a response back from our letter in a month ago.
Okay. All right, so we're moving on to policy, unless there's anything that anybody else needs to say about that. We're moving to policy BEDH, public participation as seen in Exhibit B. So, speaking of obscenities, I think it's important that our policy BEDH includes somewhere, that foul language and obscenities are not acceptable, because I don't think that's in our policy right now.
Well, I want to say this before Ms. Lunsford leaves. There is a correction that you mind telling the board?
I just wanted to point out that in the model policy, they do recommend that the books that are being challenged are withdrawn from all libraries during the challenge process, whereas in our policy, they remain in the collection.
So the model policy actually says that they remove it. I haven't found that anywhere.
Correct. It is on the last section of it, where it says, members of the committee shall read the materials referred to them in its entirety. Pending review by the committee, the challenge books or materials shall be withdrawn for use throughout the district.
So we wouldn't do the,
So right now, that's what I'm trying to do for our current policy, because our policy says it stay on the shelf. So I was going to tag it so that it needed parental permission. But if this is adopted, then we don't need that.
we'll take the lead on that. Would you prefer?
We're going both directions. Just because if a parent, just going back to our current policy, if it's not challenged officially, but a parent writes in for a certain note, to Ms. Hammond's point, who knows when that this book has been considered. So I think it's just something we just need to review, that we have an extra layer in case that happens again.
Ms. Gardner, can I get clarification on this subject for you? So, Dr. Ross, right now with our policy, any of those books, because nobody did you haven't had it filled out, with our policy, they're still on the shelf?
Those are still on the shelf. Yes, ma'am. Yes, ma'am.
But by this other policy, or this recommended, you could have them pulled
Yes, ma'am.
without all this.
Once it's formally challenged, yes.
So they still will
They
be
still have
on
to fill
there.
out, right,
Yeah.
that's what I'm getting clear. They still have to have you have to get the form. Okay, but it can be pulled immediately. And I really think that's where a lot of this misunderstanding happened, that tried to look like our board wasn't doing its job. Because I think the State Department was recommending you could pull it once it's been challenged, as you're saying. Okay,
Ms.
thank you.
Gardner, one thing just that struck me is we could go ahead, even though neither policy addresses the definition of obscenity. It does have the reference of PICO, but we could go ahead and change our policy to match the states, and then later amend it as they recommend for obscenity. So we don't necessarily have to wait. Just pointing that out.
That's what I'd like.
Was there, because I'm not sure when the policy committee will be able to meet again, is this something that we should be,
Just bring it to the whole
put
board.
it to the whole board, maybe not this meeting, because
It's
it's
too
too
late.
late, but the next meeting?
Yeah, that's good.
Mhm.
And maybe we'll have a healthy discussion there, but we'll have we can decide to either take the whole policy or.
Mhm.
The next meeting is end of April, if you missed this one.
Yeah.
Okay, all
But
right.
I don't think we're gonna be able to have a policy committee before the end of April, so, because of just the way things. And if we did, it would be right before that meeting, and it might be too hard to get it on the agenda.
Good point.
But we still wanna look at ILJ,
Correct, yes, ma'am.
or IJL, sorry.
IJL.
Okay, so, public participation,
All right, if there's no further need for Ms. Lunsford,
Thank you, Ms. Lunsford, for coming.
thank you, yes.
So, that you were talking about foul language, and I'm just, you know, this past year or so with the, basically the, I don't know, just a total disregard for those of us sitting on the board. I realize people are emotional, but, you know, we've had some things that were said and done in those meetings that just don't need to go on. And, I mean, people, I guess, in a way, we need to stress that this is not a right, that, you know, for somebody to, this is not a right for somebody to stand up there and do that. I mean, that we've been screamed at the top of their lungs, some of them. We've had things thrown at us. I mean, you know, that's not the way, you know, that we should conduct meetings. And but anyway, I want to know, one of the things I want to know is, can somebody come to public participation that does not live in our district and do that? I mean, it doesn't say anywhere, it just says community members, but I mean, if they're not a member of, let's say you came from Myrtle Beach and you just happened to find out that there was going to be a controversial subject at a school board meeting, so you roam around and go to them, and that's okay, you know, that we can have that kind of thing?
Well, we can put that in here, you know, any individual desiring to speak prior to signing can be a member of.
Or at least live in, I mean,
Within the boundaries of our school.
I mean, I hate to do that, but I mean, you know, on the other hand, what's to stop people? What's bothered me about this whole thing is that we've got people that have come in to our school board meetings and basically taken up all the seats. They've kept good people from wanting to come to the meetings because they've been so vociferous and so obstreperous that other people that have issues, you know, they feel like they're going to be heckled down if they say anything that's in the opposite vein. And I don't think that that's right. I mean, I just don't think it's right that we have a bunch of people that don't live, and I'm sure some of those people do not live in our school district that have been coming to those meetings, and they've made an atmosphere where good people don't want to come. You know, I remember one teacher in specific stood up there and was shaking, and her voice was shaking because she thought that a whole bunch of people was going to be opposed to her, you know, and they're acting so irrationally that I don't blame her, you know, and I don't want to see that happen to our meetings, and so, I mean, I don't know that we can do a whole lot about it, but we sure need to try.
Yeah, so I like the idea of adding that they have to live within the boundaries of the school district, and I like the idea of the last paragraph adding, you know, foul language or inappropriate comments will not be permitted or something. Sorry.
Well, I just wanted to, I wanted to offer a slightly different view. I go to some county council meetings. I also very clearly remember the July 2017 meeting where the board was voting on the Pineywood, the school number 13, and one of the most touching, moving, however you want to put it, was a speaker who was a Lexington County councilman who lived in Lexington and was talking about, you know, what could happen to that road based on what it, and so part of me, I understand what Mr. Lovelace is saying, but the way I think that some of these organizations handle that is you're still allowed to speak, but you have to give your address. Not just your town, but your actual address. And Lexington County, for example, requires that. You have to fill it out on the form to speak, and you must say it before you start your comments. So I would just offer that as an alternative.
So any individual designers was required to sign in.
Their address.
With, show ID and list address or something.
And give their subject.
Give their address
They-
when they speak.
Madam Chair, just I'm sorry.
No, you go.
One of the things is, to what Ms. Hammond said, if there's any language about completing the form, because sometimes the forms are not completed, and the subject, you may say one subject, and they're not germane to that subject. And I think that might be one of the most disruptive things that are going on, is that not speaking to the subject you told us about, not completing out the form correctly. So I know there are districts in the surrounding area that require you to fill out the form in order to do public participation. And I think that would be helpful. Not gonna shut down any opinion, but knowing that, that's exactly what they're speaking about. I think the chair should be aware of that before opening up the meeting to that. So, we just had some items on the administrative side where those forms are not completed, and there's an expectation to address the board.
I think maybe in the meeting, it would be helpful if somebody read, if they read, so-and-so's next, and they did fill out the form. Skip.
Yeah, and they could do that.
And then that way they know, oh, I've gotta fill out my form.
That's
or
right.
I'm not gonna get it.
Exactly.
And then the chair has the right to gavel someone down if you said you were gonna talk about
Yeah, and that's not,
sports and you got up there and talked about books, then you can say, I'm sorry, you have to fill out your form right next time, or whatever.
Mm.
So go ahead.
and, well, it's to what his point was, and, also wanted to speak a little bit about Mr. Lovelace's point. Number one, of the 20 years I've been associated with coming to board meetings, in 16 years on the board, I thought it had to be germane to it. When you signed up, it used to be that way. If you signed up to speak, it had to be on the, it had to be a subject on the agenda, okay? So I had assumed that's still what it is. And I do think that's a great idea, where if they have not filled out the form completely, then when that's read, because we're having someone else read it now, they just skip it, because it's not, but say that, and that's right, Ms. Gardner, this is not filled out correctly, so that person wouldn't know. But I'm gonna tell you something. There's always, when you're dealing with people's children and their money, which is school board's job, people get emotional. This pandemic, 2 years, has not been as normal as, it has gotten people stressed, and I have a real hard time, and maybe it's because I'm a social studies teacher. I don't think, we read that little statement about not, using profanity, not attacking anyone, but we as the board of elected officials, we are attacked by some policy they want us to change or something we aren't doing. And as long, and I agree that yelling at us doesn't need to be, and that can be my fault to say your voice is too loud and stop them. But I don't think that we need to judge the people that come that are upset about things. It's just, I remember, let's take it back to the Amex Ferry thing. There were over 200 or 300 people at that meeting, and they were talking real strong to us as a board, just as strong as some of these people that are upset about obscenity. So I am not going to sit here and cut down the public that comes. I will agree with you that they don't need to scream at us, they don't need to use profanity, but I don't think we can ever control the public that's upset about where a school's getting put or what's in the school.
Nobody said that. What they said was that we have this group of people that, and after the meetings or after they've said their piece, they go out in the hall and they decide what's the next thing that we're
But
going to
Mr.
come
Lovelace,
after them at,
we're
and
not in
that kind of
charge of that.
stuff just needs, we need to try to have a decorum in our meetings.
Well, we can. That's all we can control inside. I agree with you on that. Yes, I agree with
Or
it.
like you said, reading of sentences. If that
Yes.
happens, we need to be able to say, we're not gonna listen to that.
I agree.
So
I'm not arguing that point. I'm arguing the point that we can't control who's gonna come and be upset about something.
Well, that's true, I don't think we have, but we can control whether or not
How they talk, yes,
yeah,
I
whether
agree.
they themselves cannot control themselves.
Well, I mean, there's one thing in this policy that says that if somebody's gonna speak on the same subject, that they're not allowed to speak, to do that, you know, person after person after person, if they're not adding anything germane to, or in addition to what they're speaking about. And I know I've been to sitting meetings where 7 or 8 people get up and say the same thing, you know, over and over again. I mean, those things, you know, those things are in
Well,
here,
we can-
It just says
you
it's
know.
not necessary, it doesn't say they can, so I don't know, if that language isn't strong enough to.
Yeah, and it does say not necessary, and, I mean, I've been on both ends. I mean, you know, we all have, and to Ms. Hammond's point, I think that July meeting, I think the reason so many people got up and spoke and said much the same thing is otherwise, that board, I don't think they knew, staring out at those 300 people, how they felt, you know? And when you hear 30 people all say,
It's,
then you get it. So,
Get it.
you know, one other possibility is, Ms. Hammond, I think has mentioned, is some places do limit the total
Yeah.
time, so you're not there for 3 hours, and the staff's not stuck, you know, out
Till
there.
12 o'clock.
Yeah, so that's another avenue to keep that from happening.
and along with her point, Ms. Gardner, I know I checked with Ms. White. She said several school districts do that. You just, and people know it before they ever come, because it's in your policy, and you mention it, if we're changing it, that we want to allow 1 hour. So it's first come, first served. That way, if it's 30 people, you know, after an hour, you know, you were done. Unless, but you should also have in the policy, she said, that it could be a major point, like how excited people were about the Amex Ferry spot, and there were so many people. You might, as a board, you would have it in the policy that the board has the right by a vote to change it and allow another hour of, because I mean, anytime you're limiting the public, I'm sorry, I think it's it's a message that gets taken wrong by people that are very passionate about whatever the subject is.
Well, anytime that these board meetings go on to 10:30, we always end up having to
Change
take
it.
off the agenda what was planned for the meetings. So that's a point that we need to consider. Also, it says in here, and this is something that I've never seen happen at any of the board meetings, save Ed White, you know, just blurting out things. It was at the discretion of the board chair, an individual board member may offer a clarifying statement. So that means that if somebody gets up there and is speaking, and they have said something improper or something else, I suppose that an individual board member might clarify that statement. But is that what is really intended at our board meetings? I mean,
We've done them a couple times, but I don't know
Not
if we
many.
understood fully that I think we should be allowed, I personally think we should be allowed to do that, because sometimes, lots of times misstatements are stated and we can't clarify that. But our silence makes it seem like it's true when it's not, so.
well, I mean, that point right there, I mean, if that's the case, why should the board chair, you know, be involved in what an individual member has to say?
I
mean-
think that just means that the board chair has to tell them.
If you put your hand up, I think that's what that means.
Yeah.
And I actually did that, and Ms. Hammond did recognize me, so I can remember it at least once that we did. I mean, I like leaving it in here.
I do too.
I think, to your point, Ms. Gardner, I think a lot of, we forgot it was in here. I just thought it was important.
I actually forgotten too, because I think, oh, we're not allowed to stress that, I've gotta email them later. But,
Well, I can give you a history lesson on that. It used to be, nobody ever commented back. That was the way Mr. Gant ran it for 10 years. Am I right? I see some heads shake. You did not comment, but Mr. Lovelace is exactly right. Mr. White, many times, he was the one that answered something if he wanted to. And Mr. Gant didn't stop him, but
Is that, I mean, you know, and this is a, you know, a question, it's not rhetorical, I guess, in a way it might be, but, on down in here, it talks about how, you know, if an individual asks for an answer at a board meeting, okay, and the board the administration of the board has, you know, at least to the next meeting to answer that. And I'm just wondering whether or not that, you know, if you allow an individual board member to clarify a statement and that did not, you know, that
Satisfied.
sort of like what I, you know, right here, you guys are telling me that I'm wrong in what, you know, what I'm, you know, so what I'm getting at is that if that person clarifies and it's not what the, you know, majority of the board wants, doesn't that put us at a better disadvantage? And that's what I was trying to.
It
trying to make
does,
you know.
because that's what Mr. Gant thought as chair, which you could say, if you could answer it and be wrong, right? You know,
Yeah.
or it isn't what the board thinks.
Right, and I just didn't want to, because that then gives the public the wrong impression.
But
And
I still think that that's why it should be at the discretion of the board chair. She should decide whether or not we let comments go on too much based on what something is said, because it's not on our agenda or whatever, that means it gets out of hand.
And you could be there all night, yeah.
Yeah, well-
So I still like to let discretion of the board chair just because that allows for the control of whether or not we have time to speak to it, so.
So you,
Acknowledge, you know, do the I agree type thing, but it should be, like, if someone makes a statement and we need to correct, that would be more, so instead of saying a clarifying statement, maybe a correction statement or something.
well, I guess what I'm trying to ask here is that do we want, I mean, if that's the case and some errant board member says something, you know, that their interpretation of the way things are that really isn't the way it is, should we, I mean, just as a matter of board etiquette, you know, refrain from doing any of that? I mean, that's the question I wanted to ask you, because if the chair is going to be, you know, involved in that and somebody says the wrong thing and then it creates another discussion that goes on for 15 minutes amongst the board members, doesn't that? You
Well,
know,
that's why you really, it's probably smartest not to
Just
make
not to
any
do that,
comments,
yeah.
yeah. That's
Yeah.
probably why it was done that way.
Unless it's like it is.
A correction.
Completely incorrect, that's what I said, we need to instead of saying a clarifying statement, it should be a correction or something.
And that's usually what
It's
Mr.
not
White would say.
Yeah.
Yeah, that's why I was thinking maybe take that out of there, because see, I just was thinking that if you did that and you know, and it would just start another round of,
But sometimes
you
it's
know.
good if we clarify for everyone listening, oh, and I think that could have happened at this meeting with the books, if we could have stopped and said, we don't need you to read to us anymore, there's a form in policy KEC, would you please fill it out for us? And not let anybody else speak on it again, because that would have been better, I mean, hindsight's 20/20, obviously, but I still think that that would have allowed, you know, because if we take it out, then the only person that can make a clarifying statement is the chair.
Right.
She has the right to do that. I mean, is that what we're gonna?
I don't know. I mean, it just seems like a slippery slope, and if you go down that, then you've got, you know, obviously there's trains of thought amongst board members that may vary, and I just didn't understand, you know. I think I would never say anything because I think that'd be a dangerous thing to do.
Madam Chair, another thing too that really, that's a reason not to answer it. Sometimes it's something the superintendent needs to answer and he doesn't have all his facts and it would be wrong for him to try to answer it that night. That's really why it's brought to us and then we should come back with the right answer.
Ms. Gardner, do you need to leave?
Yes, Ms.
I
Gardner.
think so, but I really wanted us to go over the attorney things right quick. I think the attorney exhibit, the C is still good. I don't think we've changed anything except it says attorneys instead of attorney. But the exhibit D, we added and clarified some things, and anything in blue is what we discussed at our last committee meetings. So if there's any, thoughts about that, it would be important, and I have to run, but it would be important for y'all to talk about, so we can get it cleaned up for next, the next board meeting in April.
Ms. Garner, let me ask you real quick before you leave us, because I like this idea. This is like this idea of a general counsel would be like who we used to recommend a specialist type attorney that would be kind of know all our business and, you know, kind of have a feeling of everything we need, and then they would counsel us on who would be better. That's kind of what, okay.
And that's what we wanted to add, so that we could, as a board, we get to vote on who we
Yeah, I
think
like
our
that.
general counsel is, and then we go to them for
I like that.
recommendation.
I like
I think that's about right, that insurance companies handle their own cases and they don't, you know, they take over, you tender your responsibilities to them if you're the person, but the last thing in blue I really like, and that's that no legal inquiry or action will be taken against any board member without approval of board. And I think that's very important because that goes to you know, people wanting to serve on a board, and you know, I think the board owes it deference to the individual not to build cases on them without them knowing it's happening.
Okay?
So unless there's
Well, we're
anything else
good. We
that you
can-
want to add or take out of there, or,
We can adjourn.
I think that was pretty clean the way we want it, so Dr. Ross, if you don't mind letting our, you know, your legal people, your legal team, look at those policies and let us know what they think.
So can I make a motion to adjourn?
You sure can.
I'll make a motion, we adjourn. Is second?
Second.